Police know exactly which mistakes concealed carry owners make, and they're counting on you to make them. Right now, officers are trained to spot these 7 specific errors that turn a simple encounter into an arrest. One wrong move and you're in handcuffs, even with a valid permit. Today I'm breaking down the 7 mistakes police want you to make with your concealed carry, and more importantly, I'm giving you the exact tricks to outsmart them and walk away free every single time. In the last year alone, over 300 permit holders were arrested not because they were criminals, but because they fell into traps they didn't see coming. These aren't accidents. These are calculated techniques law enforcement uses to extend stops, justify searches, and build cases. By the end of this video, you'll know exactly how to protect yourself legally and never give officers the ammunition they need to arrest you. Mistake number 1 police want you to make: walking into gun-free zones you don't know exist. Here's what law enforcement counts on: you carrying your firearm into a federal facility without realizing it's illegal, giving them an easy felony arrest. You're running Saturday errands with your concealed carry. You stop at the post office to mail a package. You walk in, wait in line, mail your package, walk out. An employee spots your firearm printing through your shirt and calls police. You're arrested for violating 18 U.S.C. Section 930, possession of a firearm in a federal facility. 5-year felony. Your permit means nothing here. Police know most gun owners don't understand the federal restrictions. Post offices, federal courthouses, Social Security offices, IRS buildings, all traps. Then there's the Gun-Free School Zones Act. You cannot carry within 1,000 feet of a school. That's 3 football fields. Your daily commute probably passes 2 or 3 schools. Unless your state has a specific exemption for permit holders, that's a federal violation every single day. Last year in Tennessee, a permit holder with a spotless record was arrested at a post office. He paid $15,000 in legal fees and nearly lost his carry rights permanently. Police don't warn you. They wait for the violation, then pounce. Here's the trick to outsmart them: the zone checklist system. Before you leave your house every morning, run through this 3-point check. First, identify every stop on your route. Second, ask yourself 3 questions for each location. Is this a government building? Is this within 3 blocks of a school? Are there posted no firearms signs? Third, if you answer yes to any question, your firearm stays locked in your vehicle. Download your state's official concealed carry restriction map. Most states publish these free online. Print it out, keep it in your car. Before entering any building, do a 5-second visual sweep. Look for federal building markers, school zone signs, or prohibition postings. Make this automatic. The zone checklist takes 10 seconds and prevents felony charges. Police want you to walk in blind. You outsmart them by knowing every restricted location in your area before you ever carry there. Mistake number 2 police want you to make: volunteering information during traffic stops. Officers are trained to keep you talking because every word you say can be used to extend the stop, justify a search, or build probable cause. You get pulled over for a broken taillight. Officer walks up, asks where you're going, where you've been, what you're doing tonight. You answer politely because it seems like the right thing to do. You just gave him legal grounds to keep questioning you. He asks if you've been drinking. You say no, but you're nervous, so you hesitate. Now he's got reasonable suspicion for a sobriety test. Police want you to fill the silence. They ask casual questions that sound friendly, but are designed to gather evidence. Long day. Where you headed? Been out having fun? Every answer extends the encounter. In North Carolina, a permit holder was pulled over for speeding. The officer asked casual questions for 15 minutes while running the license. The driver answered everything politely. The officer then asked to search the vehicle. The driver consented because he thought refusing looked guilty. The stop that should have ended in 5 minutes lasted 45 minutes. Here's the trick to outsmart them: the notification script. The moment the officer reaches your window, you control the conversation with this exact sequence. First, hands on steering wheel at 10 and 2, don't move. Second, when he asks for license and registration, say this: "Officer, I'm required to inform you that I have a valid concealed carry permit and I'm currently armed. My firearm is located on my right hip. How would you like me to proceed?" Third, wait for his instructions. Do not speak again unless asked a direct question. This script does 3 things. It satisfies notification laws in the 36 states that require it. It signals you're a trained, responsible gun owner. It establishes boundaries. You're cooperating, but you're not volunteering information. Most officers will respond, "Keep your hands visible. I'll handle this like any other stop." They write the ticket, you leave. Stop over in 3 minutes. If he asks where you're going, you respond, "Officer, am I free to leave, or am I being detained?" If he says detained, follow up with, "I invoke my right to remain silent and want to speak with an attorney." If he says you're free to leave, you say, "Thank you, officer," and drive away. Police want you to talk yourself into trouble. You outsmart them with the notification script. Say what's legally required, then go silent. Mistake number 3 police want you to make: giving consent to searches. This is the number 1 tactic officers use to bypass the Fourth Amendment, and they're trained to make it sound casual and friendly. After a traffic stop, the officer hands you your ticket and says, "You don't have anything illegal in the car, do you? Mind if I take a quick look?" Most people think refusing makes them look guilty, so they say, "Sure, go ahead." Game over. You just waived your Fourth Amendment rights. Now he's tearing through your vehicle for 30 minutes, and anything he finds, even something you didn't know was there, is admissible evidence. Police are trained to phrase searches as friendly requests. Nothing to hide, right? Just want to make sure everything's safe. Only take a minute. These are traps. If you consent, they don't need probable cause. If they find an old prescription bottle, a forgotten pocket knife your friend left behind, or even claim they smell marijuana when there isn't any, you're under arrest. In Maryland, a driver refused consent 3 times on body cam. The officer searched anyway without probable cause, found drugs, and the case was dismissed because the search was illegal. The refusal was documented, and the judge ruled the officer violated the Fourth Amendment. Here's the trick to outsmart them: the consent killer. When an officer asks to search, you say this exact phrase: "Nothing more, nothing less. Officer, I do not consent to any searches." He'll push back. He'll say, "Why not? You hiding something?" You repeat, "I do not consent to any searches." He might say, "We can do this the easy way or the hard way." You repeat, "I do not consent to any searches." This phrase shifts the burden back to the officer. If he searches anyway, he needs to articulate probable cause on his body cam. If he can't, anything he finds gets suppressed in court. Most officers won't risk an illegal search when you clearly know your rights. Never explain why you're refusing. Don't say, "I know my rights," or "I've got nothing to hide." Just repeat the consent killer. Your refusal cannot be used as probable cause. The Supreme Court confirmed this in multiple rulings. Police want you to give permission so they can bypass constitutional protections. You outsmart them by refusing consent and forcing them to follow the law. Mistake number 4 police want you to make: not knowing if your state has duty to retreat laws. This is where justified self-defense shootings turn into criminal charges because you didn't understand your legal obligations before pulling the trigger. You're in a parking garage late at night. A man approaches aggressively with a weapon, demanding your wallet. You fear for your life, draw your concealed firearm, and fire. The threat is stopped. You call 911, fully believing you acted lawfully. Then the prosecutor charges you with aggravated assault because you're in a duty-to-retreat state, and the law required you to attempt escape before using deadly force. 28 states have stand-your-ground laws. You have no duty to retreat if you're in a place you have a legal right to be. But 22 states impose duty to retreat. You must prove you couldn't safely escape before using force, unless you're in your home under castle doctrine. Police and prosecutors know most gun owners don't understand which type of state they're in, and they use that ignorance to build cases. 2 years ago in Ohio, a permit holder shot an attacker with a knife in a bar parking lot. Clear threat, reasonable fear. But the prosecutor argued he could have gotten back in his car and driven away. The defender was convicted of felonious assault and paid $80,000 in legal fees. His life was destroyed because he didn't know Ohio's duty-to-retreat requirements. Here's the trick to outsmart them: the state defense card. Right now, before you carry another day, create a physical card for your wallet with this information. Side 1, your state's self-defense law type, stand your ground, or duty to retreat. The specific statute number, and the castle doctrine rules for your home. Side 2, the 3 requirements to justify deadly force in your state: imminent threat, reasonable fear, proportional response. Go to your state's legislative website and look up the self-defense statutes. Print them. Highlight the key sections. Carry them with you. If you travel to another state, look up their laws before you cross the border. A stand-your-ground state like Florida has completely different rules than a duty-to-retreat state like New Jersey. Join a legal defense organization like USCCA or CCW SAFE. They provide state-specific legal guides and attorney access. Take a concealed carry defense class that covers your state's case law. Practice verbalizing justification. I couldn't retreat because my back was to a wall. The attacker displayed a weapon. I feared imminent death or serious bodily harm. I used minimum necessary force to stop the threat. Police and prosecutors want you to act without knowing the law. You outsmart them with the state defense card. Know your legal obligations before you ever draw your weapon. Mistake number 5 police want you to make: talking to police immediately after a self-defense shooting. This is where legally justified shootings become convictions because your adrenaline-flooded brain says things that sound terrible in court. You've just used your firearm in self-defense. Your hands are shaking, heart pounding, adrenaline maxed out. Police arrive and ask, "What happened here?" You start explaining because you want them to understand you were justified. You say, "He came at me, so I shot him. I had no choice." That sentence just became the prosecutor's opening statement. The defendant admitted to intentionally shooting the victim. In the immediate aftermath of a shooting, your brain is not functioning normally. You're in fight or flight mode. Your memory is distorted. You will say things you don't mean or remember details wrong. Police know this, and they want you talking because people incriminate themselves. In 2019, a Michigan permit holder shot a home intruder, completely justified under Castle Doctrine. But when police arrived, he said, "I've been waiting for someone to try this. I'm glad I finally got to use my gun." That statement made him sound eager to kill. The prosecutor charged him with second-degree murder. He was eventually acquitted after 2 years and $200,000 in legal fees, all because of one adrenaline-fueled sentence. Here's the trick to outsmart them: the 5-sentence protocol. After any defensive shooting, you say these 5 sentences to police and absolutely nothing else. Sentence 1, I was in fear for my life. Sentence 2, I will fully cooperate, but I need to speak with my attorney before making any statements. Sentence 3, I do not consent to any searches. Sentence 4, there is the evidence. Sentence 5, there are the witnesses. That's it. Do not elaborate. Do not explain. Do not justify. When police try to fill the silence, you stay silent. They'll say, "We just need to understand what happened." You repeat sentence 2, I need to speak with my attorney before making any statements. They'll say, "If you've got nothing to hide, why do you need a lawyer?" You stay silent. Your attorney will help you provide a complete and accurate statement after you've calmed down, reviewed the scene, and can think clearly. Every word you say in those first minutes can be twisted. Silence protects you. On the 911 call, keep it simple. There's been a shooting at location. I need police and an ambulance. The threat has been stopped. When police arrive, holster your weapon or place it down if instructed. Hands visible. Identify yourself as the person who called. Then deliver the 5-sentence protocol. Police want your immediate, emotionally charged statement. You outsmart them with the 5-sentence protocol and let your attorney speak for you later. Mistake number 6 police want you to make: carrying your firearm after having even one drink. Police know the laws around intoxication and firearms are strict, and they're looking for any excuse to enforce them. You're at dinner with your spouse. You have 1 glass of wine with your meal, just one. Your blood alcohol is 0.03, well below the 0.08 legal driving limit. You're completely sober by any standard. Walking to your car, you stumble slightly on a curb, not because you're drunk, but because you tripped. A police officer sees it, smells alcohol on your breath, and asks if you've been drinking. You say, "Just 1 glass of wine." He arrests you for carrying a firearm while intoxicated. In most states, the legal threshold for carrying while intoxicated is shockingly low. In Texas, it's defined as not having normal use of mental or physical faculties, no specific BAC. In Georgia, it's 0.02 for firearms, which is less than 1 standard drink. In Pennsylvania, it's 0.08, but that's still easy to hit with 2 beers. The penalties are severe. In Arizona, it's a Class 1 misdemeanor, up to 6 months in jail, $2,500 fine, and you lose your permit for at least 5 years. But here's the real nightmare. If you're involved in a self-defense shooting and you have any alcohol in your system, the prosecutor will argue your judgment was impaired. Even if the shooting was completely justified, your intoxication undermines your claim of reasonable fear. A justified self-defense case becomes a manslaughter charge. Here's the trick to outsmart them: the zero-tolerance rule. If you're carrying, you don't drink. Period. Not 1 beer. Not 1 glass of wine. Nothing. If you're going somewhere where alcohol will be served and you plan to drink, your firearm stays at home or locked in your vehicle before you enter. Make this a non-negotiable personal policy. Concealed carry and alcohol never mix. Many states also prohibit carrying in bars or establishments that derive 51% or more of their income from alcohol sales. Know your state's specific rules. Create a mental checklist before you leave home. Am I carrying today? If yes, 0 alcohol. Am I drinking today? If yes, no firearm. It's that simple. There's no gray area. 1 drink can cost you your permit, your freedom, and in a self-defense situation, your life. Police are trained to spot impaired carriers. They look for stumbling, slurred speech, the smell of alcohol, or bloodshot eyes. If they see any of these combined with printing or accidental exposure of your firearm, they'll investigate. Don't give them the opportunity. Police want you to think one drink is fine. You outsmart them with the zero tolerance rule. Armed means sober, always. Mistake number 7 police want you to make: not having legal protection before you need it. Police and prosecutors count on you being financially unprepared to defend yourself, forcing you into a plea deal even when you're innocent. The average cost of defending a self-defense shooting is $100,000 to $300,000. That includes attorney fees, expert witnesses, forensic analysis, and court costs. Even if you're found not guilty, you're financially destroyed. Most families don't have that money available. You use your firearm in self-defense. You're arrested. You call a criminal defense attorney from jail. He quotes you $50,000 as a retainer just to start your defense. You don't have it. You're assigned a public defender handling 80 other cases who doesn't specialize in firearms law. Your defense suffers. The prosecutor offers a plea deal. Plead guilty to a lesser charge. Get probation instead of prison. You're innocent, but you can't afford to fight, so you take the deal. Now you have a criminal record and lose your gun rights forever. Prosecutors have unlimited resources. Your tax dollars fund them. You're fighting alone unless you've prepared ahead of time. Police want you unprepared because unprepared defendants plead out. Here's the trick to outsmart them: the defense shield. Before you ever carry another day, set up 3 layers of legal protection. Layer 1. Join a legal defense organization. USCCA, CCW SAFE, and Armed Citizens Legal Defense Network provide coverage for attorney fees, bail bonds, expert witnesses, and lost wages during trial. These memberships cost $30 to $50 per month, less than a tank of gas. You get access to attorneys who specialize in self-defense cases, 24/7 emergency hotlines, and coverage up to $2 million depending on your plan. Layer 2. Establish a relationship with a local firearms attorney before you need one. Find an attorney in your area who specializes in self-defense law. Have their number in your phone. Many offer free consultations. Meet with them once, explain you're a concealed carry permit holder, and ask them to represent you if needed. Now you have someone who knows you and your situation before an incident ever occurs. Layer 3. Create an emergency legal fund. Set aside $500 to $1,000 in a separate account that you never touch except for legal emergencies. This covers immediate bail, initial attorney consultations, or other urgent expenses before insurance kicks in. The defense shield means you walk into any self-defense situation knowing you have the resources to fight and win in court. You're not making decisions based on fear of legal costs. You're making decisions based on what's right and what's legal. Police want you broke and desperate. You outsmart them with the defense shield, legal protection locked in before you ever need it. Let's recap the 7 mistakes police want you to make and the tricks to outsmart them. Walking into gun-free zones. Outsmart them with the zone checklist. Talking during traffic stops. Outsmart them with the notification script. Consenting to searches. Outsmart them with the consent killer. Not knowing duty to retreat. Outsmart them with the state defense card. Talking after a shooting. Outsmart them with the 5-sentence protocol. Carrying while drinking. Outsmart them with the zero tolerance rule. No legal protection. Outsmart them with the defense shield. Police are trained to exploit these mistakes. Every single one is designed to give them probable cause, extend encounters, and build cases against you. But now you know exactly how to protect yourself. These aren't just tips. These are the exact strategies that keep law-abiding gun owners out of jail. Don't let confusion about gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week so you can carry with confidence and outsmart the traps set for uninformed gun owners. Next video, I'm covering the 5 words that instantly end any police questioning and why 90% of gun owners don't know them. You won't want to miss it.